taking an expense for the carrying of those exempt securities and getting a double tax benefit as a result. They're taking a deduction for expenses for an investment in which we can't subject to income tax.
Saying that borrowing by the parent for current operating expenses and deducting that interest when the parent owns a subsidiary which has available funds which they could tap, thereby making it unnecessary to borrow, is enough?
Under the federal guidelines, that is enough to carry.
Where is any substantial evidence? What's the test? What's the guideline?
The guideline says.
And it would strike me that you can do it any time if you wish, and you can not do it if you wish. Why isn't it completely arbitrary? I believe it's argued.
The test is if you're borrowing money for working capital, and it's agreed here that the monies borrowed was for working capital.
Yeah.
There's nothing, and at the same time, if you are carrying tax-exempt securities, which is not subject to tax, there's an inference, there's an indirect relationship.
But what's to say that the tax commission should disallow interest in one circumstance and allow interest deduction in another?
The test is,
I mean, I'm assuming that's not traceable at all as far as the initial investment in the subsidiary is concerned. Let's assume the case, the investment's made a long time ago and you've got a continuing, growing accumulation of funds. Now you borrow. The parent borrows for its own operating expenses. It has this money out there which it could have used if it wanted to take it out of the subsidiary. Under the rule you adopt, the interest can't be deducted.
only a portion of that interest. It's not all of the interest expense, which is being disallowed as a deduction. It's only that portion. There's a percentage developed based upon the net worth of Woolworth under its the tax cost of the subsidiaries. This is the federal formula.
Is it always done? Is it always applied that way, or is this discretionary?
The tax commission follows the federal guideline. This is the formula used in the federal guideline.
No, but whether to disallow or allow, is that something within the discretion of the tax commission?
Well, the statute says discretion, but their discretion is to tax, to make the disallowance. Under the federal guidelines, however, it's not all borrowings that are indirectly attributable to a subsidiary. If it's an unusual expense, it's not ordinary working capital. Say if Woolworth were to go out and borrow money to build 30 new stores, that would not be ordinary working capital. An expense, the indebtedness would not be for ordinary working capital. That has nothing to do with the subsidiary capital. In fact, here, some of the interest expense was not in any way associated with working capital. For cancellation of the leases.
Dow, then let me come back, if I might, to something the Chief Judge asked you, and another thing you mentioned in response about whether this was for merchandising. And you mentioned the double tax benefit as the one of the motivations for the commission, the taxing authorities, to take that position. Looking at it from the taxpayer standpoint, though, couldn't it be viewed as the taxing authorities depriving the taxpayer of the legitimate deduction, even if I take your, prorated limitation that it's $1 for $1? It's depriving them of the deduction with respect to otherwise legitimate expenditures, is it not?
It's depriving of a deduction because the purpose of the deduction of the expense was incurred to hold securities which are not, the income of which are not subject to tax by New York.
But that's not an illegitimate purpose. Just because it's not taxable doesn't mean they can't do it for that purpose, is it?
It would
why I'm
not
trying
be,
to
I submitted that it would not be a legitimate purpose. Making a clearer example using the federal law, when the under the federal law, if a taxpayer holds tax-exempt securities, say municipal bonds, goes out and borrows money when it knows it needs money to carry on its business for merchandise or wherever, and goes out and borrows these tax-exempt securities, the federal government will disallow that deduction. It's the same situation here, because they are, what in fact, pyramiding, well, they're using leverage in effect to avoid taxes on income which ordinarily should be subject to tax. They're taking a deduction for something which is not related to their business expenses, and that's why the deduction is disallowed here.
Under the federal rule, there need be no direct connection between the borrowing and the acquisition of the tax-exempt securities.
That's correct. There can be an inference that there's
That's only because you borrow while you're holding them. That's enough?
for the purpose of carrying, yes. It's either to purchase or to carry. And what they're doing here is they are carrying these subsidiaries and going out and borrowing money, ordinary working capital, and at the same time obtaining income which is not subject to tax because of using the leverage of ascribing all this money to working capital.
Thank you very much. Now, any compulsion, Mr. Bray? Good, thank you. Matter of James Lenney.
Ready for please.
Mr. Feistinger?
May it please the court, my name is Jerry Fessinger, and I would first like to address the court as to a previous motion that I made before the court to allow the petitioner to expand the record to include all the material that was submitted before the commission on the petitioner's application for redetermination or reconsideration of the determination.
All right, that will be considered.
Thank you, Your Honor. The first point that I would like to talk about is the fact that I believe, and the petitioner contends, that the sanction was too harsh. Article 6, Section 22A provides that the commission has the power to remove a judge for a persistent failure to perform his duties. The facts before this court, and when you look at the record, you see the Department of Audit and Control reports listing the judge's cases. And if you add up those cases, it shows that he averaged over 1,500 criminal, traffic, and civil cases a year. He did this without a clerk, in addition to which part of his duties was to handle and manage over 7,000 parking tickets a year. The commission has basically found that he neglected 41 of those cases during a 5-year period, or excuse me, a 4-year period. That gives him less than 1% of the cases that he allegedly neglected, and he never did neglect those cases. They were put on the calendar, the attorneys appeared, there were adjournments granted, but they weren't neglected, and I think that's very important to remember here. He was charged, he had a busy rural court, and he had to work with the attorneys, and if the attorney had to be in 2 or 3 courts, he had to go along with that. The criminal cases, not one 30-30 motion was ever made in any of those 36 criminal cases.
These adjournments requested by the district attorney, or?
Some of them were requested by the district attorney, some of them were requested by the defense counsel themselves, but they were consented to. And he tried to manage the court the best way he can. And obviously, if you've got a caseload like that and no clerk, it is extremely difficult to manage these cases and be absolutely perfect. And what the commission is requiring by this decision is, I submit, perfection. They're asking him to be perfect. Don't neglect any cases. Don't have every single one of the cases.
Mr. Fisinger, what is the definition of neglect which is used even as to the alleged 41?
That he didn't apparently call them, make sure that these cases went to trial. In some cases, for example, the felony cases, that he, quote, didn't refer them to the grand jury. Well, he doesn't have the unilateral power to refer them to the grand jury. But there wasn't a felony hearing. Well, in some cases, neither the district attorney nor defense counsel wanted a felony hearing for whatever the purposes are.
And what sanction would the commission, do you think, suppose should have been performed by the judge in his adjudicative authority once having adjourned the case and putting it aside or in the suspense calendar or wherever? What sanction would the commission impose on the, or responsibility would the commission impose on the judicial officer to exert against the prosecutor who carries the burden?
I think the real, what should have been done is, or in fact was done in many of these cases, the sanction, I assume you're referring, Judge Balacosa, to the sanction the commission should have imposed on the judge?
No, what sanction would the commission suppose that the judge should impose for moving the case along?
It didn't say anything in its decision as to what he could have done or should have done. When two counsels asked for an adjournment and it's consented to, it's a consent adjournment. In fact, I can't remember the case right off the top of my head, but there was a recent case where a judge was in New York City and the judge did not allow consent adjournments, and the judge was censured for that. And I think, you know, that's what's happening here. There's certain cases that unfortunately do get put aside. That shouldn't happen ideally, but we don't live in an ideal world, and certainly in Herkimer County, it's in the village of Herkimer, it's not an ideal court because of the caseload it has. And one judge and no clerk. I think he did remarkably well to be able to only have 41 cases, quote, neglected.
There were other elements of misconduct that supported the result.
There were, well, basically there were 4 counts, Your Honor. The first count was the neglect of the cases. The second one talked about a particular case. The third was a failure to timely file the reports to audit and control. And the fourth was failure to answer the judge's or the commission's inquiries. In fact, if the record were open and expand, in fact, the petitioner did answer those inquiries. As far as the audit and control, yes, they were late, admittedly. But that's consistent with a judge who's in a busy rural court, no clerk, has to perform all these things by himself, and he's overworked. And there's no question about the fact that the system is wrong, but you don't throw out the judge because you don't like the system.
Mr. President, you say there were no unresponded to letters?
Your Honor, there was a letter of September, it was a September letter, which he did not receive until late. The letter requested that, number one, notifying him about the audit and control reports were late, and in fact, they had been filed 15 days before the letter had been sent. And the other was repeating the request of the previous letters. And he thought in good faith that he had, in fact, answered those letters. And thought, if you can see the pattern, even at the record presently before this court, there's sometimes 2 or 3 weeks before he gets a certified letter. My second argument is the fact that the petitioner was denied due process. The rules of the commission clearly say that he shall have ample and sufficient time to answer the issue of sanctions. And in fact, he wasn't given any time because he never received those letters. And the commission doesn't even give you an affidavit of regular mailing that those were sent. Not only that, but they were addressed to the court as opposed to the judge. And if you read his testimony, and if you look at it, every letter that the petitioner denies getting was addressed to the court itself. It had his name on the front of it, many of them, had his name on top, but it said the court, and apparently the post office continually sends that mail to the village hall. and then it's put in his desk, or it may not be put in his desk, who knows? In fact, the commission's determination not to reconsider was sent to the wrong address, certified mail, and it ended up with an employee of the village getting the letter and never mentioning it to the judge and put it in his desk.
He did get some of the letters that were so addressed.
He did get some letters that were so addressed, but from the commission itself, any letter that was addressed that way, he did not receive at all. And it was...
I didn't understand the distinction you were making.
Yes. See, the letters that I'm talking about were letters sent by the clerk of the court, or clerk of the commission, rather. And for some reason, instead of addressing it to Herkimer Village Justice, it had his name on it. Instead of saying Herkimer Village Justice, it said Herkimer Village Court. And it gave his private office box number. And they didn't put it in the private office box. Anything that said justice on it, they put in his box. When they saw court, they said, oh, that's got to go to the court, apparently, and left it in the mail for the general village mail. And whatever happened to it, we have no idea. But he didn't get it.
Is this what we have in the original record, or is this the subject of your pending motion?
No, Your Honor, what you have in the record is the letters. We have just stated that we didn't receive them, and there's nothing in that record, nor the expanded record, that shows that these were ever sent. There's nothing. There's just a letter there. There's no affidavit of mailing whatsoever.
Charge 3 apparently was found, and it says from June 1984 to July 1986, respondent failed to report and remit court funds to the state comptroller within 10 days of the month following collection as required by the statute.
That is correct.
I gather that really reflects many instances of times when particular funds weren't remitted within the 10-day period.
Right.
Question, how much overdue were they?
Your Honor, I believe there is in the record, there's a whole list of how many there were. The most serious ones, in fact, there's a whole list of the reports. And if you can see that they're done, some of them were only 4, 7, 8 days. Some of them were admittedly, the May 1986 admittedly was 84 days late. Your
How
Honor.
many days?
84. Yes. They were filed on September 6th. All the reports have been filed. If you look at the reports and take the time to go through them, you'll see that they're painstakingly done, and done by the petitioner himself. And that's one of the problems with having that many cases and trying to get everything done, particularly with the parking tickets, is another big problem that he had. And they've always got there was never any money missing or anything of that nature, and it was promptly deposited in the judge's bank account.
What page in the record were you just looking for?
I'm sorry, Your Honor. Let's see. It's page 537. The fact is that he was not given proper notice of the sanction memorandum. There's no proof that he ever was even sent. And I think it's very important that due process be given a petitioner in this matter. There is evidence that the commission didn't even read the record. For example, in the Ferraro case, they accuse him of sending a flawed transcript or an incorrect transcript. Yet in the record, 4 different places, the figure used by the petitioner was the exact same figure supplied by plaintiff's attorney. And it's right there in his letter enclosing the transcript. He explains it. And I think it's very important to look at exactly what was done and take everything in context. Thank you, Your Honor.
Thank you very much, Mr. Chairman. Ms. Seveny, there's something that's troubling me a bit about this case. There's no allegation of dishonesty here with respect to this judge as I see it. It's a question of his not fulfilling the mandate that a judge shall dispose promptly of the business of the court. In addition to, of course, his not responding to the inquiries of the commission. That's basically it, is it not?
That's correct, Your Honor.
Now, if in a criminal context the judge does not dispose promptly of certain cases, there are statutory remedies, speedy trial rules, and so forth. And on the civil side, I would imagine there are ways of mandamusing through Article 78. In certain instances, on both the criminal and civil, there's certain appellate review with respect to the dispositions made of judges and the timeliness of those dispositions. Why does that come within the scope necessarily of judicial discipline?
Well, of course, there is a requirement in the rules governing judicial conduct that a judge is required to dispose promptly of the business of the court. Now, where you have what is emerging from the record in this case is that you've got a judge who has some very serious problems in dealing with his judicial responsibilities. We've got delays in disposing of cases, delays in scheduling cases, ignoring letters from attorneys about these cases, lateness in reporting to the state and sending funds into the state, and then when you add to that, not cooperating with the commission and not responding to the commission's letters throughout this proceeding, what you have when you consider this as a whole is a really cavalier attitude about his judicial responsibilities and a really serious problem with coming to grips with that.
He might well argue, as he has today, that part of that problem is by virtue of an enormous caseload. And the point that concerns me is we have some 3,000 judges in this state, as you know, and many hundreds of them in extremely busy areas do have that enormous caseload. And sometimes it's not as easy to deal with it as it might appear superficially. For example, in your papers, you indicate at one time that if the adjournment is sought and the judge denies the adjournment, that the judge can force the person to go to trial. I'm not so sure that this court has ever said that in all instances. And I just wonder where that authority comes from.
Well, I think that when you consider the factor of the large caseload, you have to look carefully at that. There's no indication in this record of how many of those cases are really mailed-in guilty pleas on traffic cases. He says that, in fact, he conducts very, very few trials. So that should certainly be considered. But I think that what it comes down to is that the kinds of delays that you have here are not the delays that come from having a large caseload. For example, in one case, I think it's People v. Thompson, he granted 20 adjournments over a period of 2 years. Now, I submit that that takes...
At whose request?
I believe that those were at the request of the defendant's attorney. And apparently the DA went along with this.
District Attorney consented to them.
Excuse me?
District Attorney consented to them.
Yes, that's true.
Why would that be bad?
Well, because a judge has a responsibility to move his cases along, and where you have a pattern here.
But the District Attorney found no fault in it. He consented. There may
Yes.
have been other reasons for it, I don't know, but, you know, the Chairman is requested, District Attorney says, I consent.
Well,
What is he going to, Judge, you say, should say, you cannot consent, Mr. District Attorney, I'm forcing this case to trial.
well, what he could say to both sides in order to move things along is he could say that...
But he could say, but it's, show me where that is wrong.
Well, it's wrong where it gets to a point where, as several of these cases are in the record, they end up getting dismissed in the interests of justice because they've been languishing on the calendar for years and years that you get to a point where everyone, I don't know, loses interest in them. One defendant dies, another defendant leaves the state and can't be found, so they're never brought to
Those
justice.
cases where the district attorney was not ready, and therefore didn't push the cases?
Well, it's not always clear in the record what the reasons for the delays are in some of these cases. The point is that when you look at the overall picture, you see this certainly most clearly in the civil cases. If you look at Ferrari v. Barone, which is described in Charge 2, what you have here, it's a small claims case. You have the plaintiff's attorney clamoring and pleading with him to schedule a trial. This goes on for 2 years. Now, clearly, in a case like that, he can't say, well, you know, no harm was done, nobody was injured. In fact, at one point, he actually did schedule a trial, but the defendant's attorney in that case was this Mr. Aney, and as the judge testified, he'll always grant a request for an adjournment from Mr. Aney because he always has a good reason. So the trial was adjourned and it was never rescheduled, and that went on for 2 years.
Ms. Savigny, but you're
Yes.
not asking, I take it, on behalf of the commission for removal from judicial office for that one incident. As a matter of fact, you've said, look at the entire picture, and what I'd like you to do for me, if you would help me, is in looking at the entire picture, the finding that I find of most concern in the determination of the commission, and it's very alliterative, but I would like to know what the definition of it is a persistent and pervasive pattern of neglect. Now, in the context, the overall picture that you describe of the numbers, whether they're mailed-in items or trial items or whatever kind of items, which it seems to me is the burden of the commission, which has brought the charges and must prove them, what does that mean? 1%? 10%? How do we know what a persistent and pervasive pattern of neglect is?
Well, I think the pattern of neglect comes not only from the delays in the specific cases that are set forth in this record, but it also includes the lateness in reporting cases and submitting monies to the state, his ignoring letters from attorneys, and in addition to that, his failure to cooperate with the commission and failing to respond to the commission's letters. I think that's all of a pattern.
All those things being taken, any particular number of those in percentage out of the gross, or is that a judgmental thing? Because again, we must come back to a word pattern which connotes much more than I've been shown so far.
Well, I don't know what percentage would constitute a pattern. I think if you look at what happened in Ferrari v. Barone, that his mishandling of that one case in it and of itself is so egregious.
That's not going to make a pattern, though, is it?
One case does not make a pattern,
Okay.
but there's more in this record than that one case. That's an important case because we've got a detailed record of what exactly went on in that case. Now, I would just like to address the charge that he failed to cooperate with the commission, because that's very serious and it typifies the kinds of problems that we have in this case.
Before you do it, that, if I may, just come back to one question I'd like to get clear. Is it censurable judicial conduct when a criminal case remains pending for a long period of time because the DA asked for a series of adjournments agreed to by defense counsel, or defense counsel asked for adjournments agreed to by the district attorney, or a combination of those two?
I'd say no, and I'd say if that's all we had in this case, then I don't think we would be here, but it's not all we
I just want to
have.
get an answer that if the position is no,
Although,
a well-aged case remaining on the calendar for those reasons is all right.
that's That's probably true if you're talking about criminal cases only. Certainly with respect to civil cases, you've got a whole different set of problems and, excuse me, yes.
Talking about criminal cases, assume that the defendant and the district attorney continually agree to grant adjournments. And the judge now says, look, I want to set a time certain for this and this side, you both be ready.
Or else I'll grant a motion to dismiss or something.
All right, then the defendant's attorney comes in and says, I'm ready, and the district attorney says, I still haven't been able to get my witnesses ready. Can the judge dismiss?
Can he dismiss? He
You
can...
argue there's
yeah.
part of the recommendation or report of your counsel which indicates that if the judge didn't want to grant a further adjournment, he could order a dismissal.
I'd say that it might come to a point where it's been pending so long, and if the DA continually says that he's not ready, the judge could indicate that, well, I'm going to schedule a trial 2 months or 3 months down the line, and if you're not ready by then, I might consider granting a motion to dismiss.
And then the time comes and the district attorney says, I'm not ready.
Well, that's obviously within the judge's discretion. You have to look at the facts
Both sides say they're not ready.
in each
Then what
case.
would the sanction be?
Well, I don't know if you have that here.
Now, the point I was making is that you started as saying that it was at the discretion. Were you saying the discretion of the judge? Because I assume by this determination, you're saying that a point is reached where that judge doesn't have any discretion anymore.
Well, the point is reached where maybe both sides are taking advantage of the situation, and the result is that the case is never going to come to trial, and it languishes on the
So if the judge
calendar,
orders
and
a
then...
dismissal against the people in an instance like that, a very bad person can go free.
Yes?
And you would feel then that the judge had vindicated his obligation and duty. I must tell you that we have a case now pending before our court which questions whether or not the court has the power to dismiss within a certain time limit for failure on the part of the people to be ready.
Well, I will watch with great interest for the outcome of
So
that
will
case.
we.
Yes.
To be certain of the cases that
Yes.
form part of this pattern, on the first count in particular, do I understand that none of these cases are instances where both the defendant and the district attorney have consented to the adjournment? Or both the defendant and the plaintiff in a case?
Well, clearly as to the civil cases, you've got instances here where clearly one side was not consenting and in fact was pleading with the judge to set a trial, and he refused to do so for long periods of time.
Do you have on your list any instances where both sides have consented to the adjournment?
Possibly for certain limited periods of time, but not throughout the entire course of the case.
And in the criminal cases, do I have instances on the list of this forming the pattern where both the district attorney and the defendant have consented to the adjournment?
There were certainly times when the DA was apparently not prepared to go forward, and then times when the defendant was not prepared to go forward. But then you also...
And in those cases, the other side consented?
I'd say that happens sometimes. What I would like to just address briefly, though, is this charge of failing to cooperate with the commission, because it is serious, and what it comes down to is this. The commission sent him 4 letters during the course of the investigation. They were sent by certified mail, and we know that he received them, and no response was ever received to those letters. So that was the basis for the charge. And where you have a judge who fails to cooperate, who fails to answer 4 letters from the commission, and then is not heard from at all after charges were served, and isn't heard from at all until after he gets the determination of removal, then I don't think there's much doubt that just that, in and of itself, is extremely serious. So the only issue is those 4 letters that he now claims he did send, 2 that were supposedly sent during the investigation, and 2 that were sent after he received
Serious enough for
the
removal?
charges. Yes, I do. A judge just can't ignore the entire proceeding with impunity and then come in at the end waiving letters that he supposedly sent after he had noticed time and again, that's what this record shows, that he had noticed that these letters were not received and did nothing about it.
This judge claims that he didn't receive your letters. Is it possible that you didn't receive his?
Well, the letters that he claims he didn't receive from the clerk are an entirely different issue because he claims that he didn't have notice and opportunity to appear on the issue of sanctions because he did not receive those 3 or 2 letters from the clerk of the commission. And of course, our whole point is that he did receive the memorandum on the issue of sanctions. He admits that he received it. And that was after he had received the charges. He had received the motion for summary determination, and now he received the memorandum on sanctions, which told him that the motion for summary determination had been granted, that counsel was recommending the sanction of removal. So that told him everything that he needed to know, even if he never received those letters from the commission clerk, which were, of course, sent by first-class mail to his correct address. It's interesting that all the letters that he says he didn't receive were sent by first-class mail, and everything that was sent out by counsel to the commission was sent by certified mail, so of course he admits receiving those. They were all sent to the same address. It's his personal post office box number.
Did I mistake the assertion that the letter of notice for opportunity to address the sanction was not sent by certified mail?
None of the letters by the clerk of the commission were sent by certified mail.
So that one from you to the judge was not by certified mail with respect to the key thing he's complaining about in terms of opportunity to address sanction?
No, there was a letter from the clerk of the commission to him, and that's what told him about the opportunity to come in and appear for argument and submit a brief.
Was that certified or not?
That was sent by the clerk of the commission, and it was sent by first-class mail. He never received it.
I'm only asking
Right.
you whether it was sent by certified mail, and
No.
you've said no. Other letters you did send by certified mail.
Everything that was sent by counsel to the commission was sent by certified mail. So we know that he received it. The sanctions memo, which is really key, was sent by certified mail, and he received that, and that told him that the motion for summary determination had been granted and that commission counsel was recommending the sanction of removal. So even if he never received anything from the clerk of the commission, that told him everything that he needed to know. It told him the status of the proceedings. It told him that if he wanted to come forward and be heard, he better do it. And what did he do when he received that? By his own admission, he did nothing. He did nothing. He wasn't heard from at all until he received the determination of removal. Now he says that he didn't receive that memo until a week after the date that had been scheduled for argument. All right, but you have to consider that since he says that he never received the letters from the clerk of the commission, he didn't know when the date for argument was. For all he knew, it was still weeks or months away. And what did he do? He did nothing. So the commission's determination was not issued for another 2 months. He had plenty of time to come forward at that point and say, I want to be heard, but he didn't. So that's emblematic of what's going on in this whole case. You've got a cavalier attitude towards what's going on. You've got delays in disposing of cases, notwithstanding that he'd previously been cautioned by the commission for exactly the same thing, for delays in a civil case. So when you consider all of those factors together, I think that it comes down to a lack of fitness for judicial office.
Thank you very much.
Thank you.
All please rise. Hear ye, hear ye, hear ye. All persons having having any further business before this Court of Appeals, held in and for the state of New York, may depart hence, and appear here next Monday afternoon at 2 o'clock, to which time this court now stands adjourned.